Welcome to LegalBid, your fast pass for choosing legal help. In this video, we will provide an overview of an alternative dispute resolution process called arbitration. Arbitration is a method where parties involved in a dispute submit their cases to a qualified arbitrator instead of a court. This alternative dispute resolution process is different from mediation, where a mediator works with the parties to settle their case but who does not impose a solution on the parties. In arbitration, the chosen arbitrator, or panel of arbitrators, makes a decision called an award in the case, and that award is confirmed by a court and becomes enforceable as a judgment. Arbitration is less expensive than traditional litigation, mainly because it is a faster way to resolve a dispute than preparing for a trial in court. It can also be simpler and private. The parties to arbitration also have the benefit of choosing their own arbitrator, who can be an expert in the party's industry. Or, if they cannot agree on one arbitrator, they can each choose an arbitrator and agree on a third neutral arbitrator. However, while arbitration is typically described as a method that is agreed upon by the parties, in reality, it is often included as a provision in all types of contracts, including those where one of the parties is not as knowledgeable about the different types of dispute resolution methods available and may not fully understand the advantages and disadvantages of agreeing to arbitration. Mandatory arbitration clauses might prevent the party who did not draft the contract from pursuing a jury trial when a jury trial might be that party's preferred method of resolution. In these types of lopsided contracts, where arbitration is mandatory, choosing an impartial arbitrator might be difficult for the contractually weaker party. The arbitration clause in many consumer or employment contracts tend to work in favor of the larger employer or manufacturer because the consumer or employee is not as legally sophisticated as the other side. Arbitration clauses in contracts will often choose the rules that will apply to the arbitration proceedings by choosing the arbitration forum within the contract. An arbitration forum is a private company that conducts arbitrations. Each forum will have different rules, locations, and arbitrators. If the arbitration clause in a contract does not choose the forum, or if the parties have agreed to take a non-contractual dispute to arbitration, the parties can agree on a forum. When deciding on a forum, the parties should consider where the forum can hear their case. Can the case be heard only at a regional office or where the parties are located? It is important to consider who available arbitrators are and their experience with the type of issue being arbitrated. Cost and the amount of flexibility arbitrators are given under the procedural rules of the particular forum are also important. How a party starts an arbitration will depend upon whether a contract between the parties demands arbitration, whether the parties agree before suit is filed in court to arbitrate, or whether the parties agree after suit is filed in court to arbitrate. If arbitration is required by the parties' contract, one of the parties will file a claim with the arbitration forum to start the arbitration process. If the parties agree to resolve a dispute by arbitration before either has filed suit in court, the parties will choose a forum or agree to work outside of a forum and choose arbitrators who will follow the state law provisions regarding arbitration. Once an arbitrator has been chosen, one party files a claim to officially begin the process. If the parties agree to arbitration after a court case has been opened, but no arbitration agreement is in place, Arizona law provides that the court can appoint one or more arbitrators. In determining where arbitration will take place, the arbitrator will consider where the parties are located, where the relevant documents and witnesses are located, the cost to the parties to travel, and the place where the contract was performed or where the dispute arose. If an agreement to arbitrate requires that 3 arbitrators hear the case, the rules of the forum will determine how the 3 arbitrators will decide the case. For example, some forum rules provide that the award will be based on a majority of the arbitrators, while other forum rules provide that the third neutral arbitrator has the power to render the award alone if the decision by the panel is not unanimous. If an Arizona state court has chosen the arbitrators, the award may be rendered by a majority. The arbitrator will set a time and place for the hearing and give notice to the parties, and also determine what evidence will be allowed at the hearing and what discovery between the parties will be allowed. The arbitrator has the power to issue subpoenas to witnesses and for the production of books, records, documents, and any other relevant evidence. The arbitrator has the power to enforce the subpoenas with the same authority as a court. In essence, the arbitrator has the power of a court in regard to enforcing the rules of discovery and conducting the arbitration. The hearing itself is conducted similarly to a non-jury trial, but the arbitrator has the most flexibility in rendering an award. Sometimes arbitrators will resolve cases based on fairness to the parties and not necessarily on the law relevant to the issue. If an arbitrator decides the case based on fairness and not on law, the parties to the case cannot appeal the decision based on the arbitrator's failure to follow the law. After an award is rendered, the party who has won will seek confirmation of the award by filing it with the court. The opposing party has 20 days to object to a judgment being entered against them based on the award. If the opposing party objects to the award, they file a pleading with the court and not with the arbitrator. Arizona state courts will not set aside an arbitration award unless the opposing party can show that the award was granted by corruption or fraud, or that a neutral arbitrator was partial or exceeded their powers. The court will not vacate an arbitration award because the court would have ruled differently based on the law. A confirmed arbitration award has the force of a judgment and can be executed on by garnishment or levy or any other legal means. Arbitration is only one of two popular alternative dispute resolution options. The other option is mediation. If you are involved in a dispute that will be mediated, please see our video here on LegalBit for a full overview of mediation.